All right, let's move on to trust. So really, I mean, it may sound pretty boring, but it's actually a pretty interesting topic. Um, and your author has some pretty good examples, um, but it might be worthwhile for us to kind of review what these terms mean a little bit. Well, first of all, when did the trust responsibility come about? And this mentions the document that I often refer to as sort of the beginning of the trust doctrine. Now, we all think of John Marshall, right, as creating this trust doctrine in 1831 and 32. Um, but I think he was probably interpreting the wordage in the Northwest Ordinance. And that wording in the Northwest Ordinance came out of a treaty, a peace treaty. I believe it was a peace treaty made with some of the tribes in the Ohio Valley that were still basically fighting for the British after the War of Independence was over. Treaty of Greenville, I think. Don't quote me on that. But anyway, it wound up in the Northwest Ordinance. So the treaties in the Northwest, early treaties in the Northwest Ordinance, always have a statement about we recognize this tribe, all right, and this tribe recognizes us. This tribe recognizes the authority of the United States, and we will live in peace and harmony forever, all right. That the Northwest Ordinance is quoted on page 285, or a portion of it. It says, "The utmost good faith shall always be observed towards the Indians. Laws founded in justice and humanity shall from time to time be made for preventing wrongs being done to them and for preserving peace and friendship with them." And then there's that other part that we don't read enough, and that says, "From the commencement of our government, Congress has passed acts to regulate trade and intercourse with the Indians and manifest firm purpose." Well, that's not it. I'm trying to think of a different one. Well, also in the Northwest Ordinance, it says, the United States won't take any land by force except through war, just war, something like that. But the utmost good faith, that's the title of a lot of books on Indian policy, or at least the phrase is used a lot, utmost good faith. But it comes to us early on, and so the Congress is always, basically through legislation, controlled the relationship between the Indian tribes and the United States government. We know that. So in this chapter 14, we're going to look at, we'll try to define, what is the trust, how the trust was. We'll look in Seminole. We'll look at how the United States government, its trust responsibilities were defined and codified, and we will be able to identify when the trust doctrine has been violated, and we're going to talk a little bit about Cobell versus Salazar, the Cobell case, or the Cobell litigation, as it's called. So I'm going to ask you a question. If you read the little scenario about the Seminole Nation, and the scenario was something like this, if you recall, the Seminole, the government was dispersing annuities to the people of the Seminole tribe, Seminole Nation, and after a time, the tribal council asked the federal government to distribute the annual payments directly to the council so that the council could distribute them. And, the council was corrupt, and supposedly everybody knew this, but the United States federal government did it anyway. Okay. So then, the years later, the tribal members file a class action against the United States government for mishandling that distribution of payments. These payments were more than likely for some resource that was used. But anyway, the question is, if the government had decided not to distribute or not to distribute the payments through the tribal council, how would that have been perceived?
Probably like more overreach than and withholding payments because they're corrupt, because they're known to be corrupt versus actually paying and not, or if you don't pay, then you're not fulfilling your trust doctrine. So that's kind of your
Yeah, so,
catch.
yeah, it's kind of a catch-22 for the poor government, right? It really is kind of a catch-22 because if the federal government, if the Bureau of Indian Affairs says no, we're not going to, even if the tribal council has this request and they say, well, our tribe wants us to distribute the payments. The federal government, if the federal government says no, then that's sort of denying their sovereignty or being paternalistic, right? If they say yes, and they did, then years later, it's found that there was corruption, and so the federal government becomes liable. Anyway, kind of an interesting facet of the trust doctrine. Thing to know about the trust doctrine is it's often the only barrier that tribes have um, from being overrun, or just completely stomped into the ground by the federal government. So the trust doctrine is interesting the way it works. So let's look at this Seminole case, and to understand that, um, um, the trust doctrine itself was sort of formalized by this case. The Seminole Nation, said, okay, we're going to call this. You're calling this trust. So let's look at financial law, and look at what a trust is. So I don't know if any of you are familiar with what a trust is. Sometimes, historians will refer to the big trusts back in the Gilded Age, the monopolies, the oil and steel monopolies, coal monopolies. That's not what a trust is in this case. Although a corporation is created to protect itself, protect its assets. Um, uh, in this case, if you want to look at a ward and guardian relationship, the components of a trust usually, and this is not included in your book. The first one I put is the settlor. Who is a settlor in the case of a trust? The settlor is usually the person who creates the trust, the person who is sort of distributing the asset or owns the asset and is passing the asset on to somebody else. However, that person or persons, the beneficiaries, number 4 on the list, the beneficiaries are for some reason incompetent, and that's not intended to be derogatory, but basically they are not of legal age, or they are not capable for whatever reason, disabilities or something, capable of taking care of their own financial affairs, something like that. Okay, so the trustee is this third party somewhere between the settlor and the beneficiary. The trustee is an individual or an institution that is given the ability to control the trust corpus or the assets. Okay, so the trust corpus just refers to, let's say it's a bank account or stocks or real estate, something like, or a whole bunch of that stuff. And say it's $500,000, and the trust corpus is made up of all these different things. Um, Real estate is one that's really difficult because real estate, if you have a house or something, it's got to be repaired, it has to be kept up, you have to have utilities to pay for it. Um, so oftentimes it's the beneficiary is not of age or sound mind to care for that asset right off. So typically the trust is created to allow the beneficiary or beneficiaries to come of age and become responsible enough to be able to handle that asset without losing it. Okay? So the trust court. Let's think about who these. In the United States, this thing that was created called the trust doctrine. Who is the settlor? Well, let's do the easy one first. What is the trust corpus? The asset.
The well-being of Native Americans.
Okay. It could be the well-being, and how in the past, before treaties, did Native Americans take care of their well-being? I don't mean to play devil's advocate necessarily, but
They took care of themselves.
What?
They took care of themselves.
How? From what?
I guess hunting and gathering.
Where?
America.
On the land, on their land,
Yeah.
right? So ultimately, the trust corpus goes back to their land, what they gave up. And they gave it up to the federal government, who is the caretaker of that corpus, that trust corpus. The caretaker, the United States federal government, is the trustee. Right? So the settlor, who would the settlors be? It's not mentioned in your text. I mean, theoretically, who would the settlor be? I'm thinking the ancestors of native peoples, particularly those who signed treaties. And those settlors weren't stupid most of the time, right? Like if you look at the Cheyenne, Arapaho, well, I guess it was if you look at the treaties of 1867 and 68, the Treaty of Medicine Lodge Creek and the Second Treaty of Fort Laramie, those negotiators on the tribe side were cognizant enough and aware enough that they, and the example of the allotment agreement for the Osages, they had the good sense to have put on very strict requirements on divvying up the reservation, allotting the reservation. In the case of the Plains tribes, they created stipulations that 3/4 or more of the adult men in the tribe have to approve of the allotment before it can take place. Well, the government broke those treaties. They broke those stipulations. Or in the case of the Osages, they retained the mineral rights in common to the tribe. So they had a lot of ingenuity, a lot of they negotiated for the future. They knew that what they were doing, or at least what they assumed they were doing, was taking care of the future of their people. That land was the trust corpus, and that land was the way of making a living and taking care of your well-being. All right, so it ultimately comes down to land, at least to a geographer. So the settlor, the trust corpus, the trustee, the beneficiary. Everybody straight on that? So the beneficiaries, in the case of the U.S. trust doctrine, would be Native American people, or at least members of federally recognized Indian tribes, right? When? Forever, in perpetuity. Treaties were made, and they were intended to be, at least in the writing, forever. And so taking care of that trust corpus and protecting that trust corpus is the role of the trustee. It's battles over control of the trust is pretty common occurrence in United States litigation, right? So there's often a lot of ill will and sort of contest for control of things like this. The trustee must be an institution or a person who can be trusted, can have the integrity to protect the asset. The number one thing they're supposed to do is protect that asset. I'm talking about in trust law here. So how is when does a trustee violate that trust? Trustee violates that trust when they abscond with the trust corpus, or they utilize the assets in a way that doesn't build them, doesn't increase them. So the United States record on that being, the trust doctrine is pretty awful, isn't it? Doesn't mean that the trust doctrine can't be improved. And I think that in the self-determination area, you'll see that the government has been a better trustee. Okay, so in the case of Seminole Nation versus United States, it basically laid out some standards of what this trust doctrine really means, and we'll see in some cases how that, the Mitchell cases particularly, how that works. All right, let's take a break here in a little bit. But before we go there, let's answer the question: can you trust the trust doctrine? Or at least that was one of the subheadings in this chapter. Will the United States Constitution protect the trust doctrine? The United States Constitution doesn't do much at all for tribes. They're kind of specifically written out of it. And we know that Congress, whenever it pleases, can abrogate or amend treaties. They can break treaties if they wish, if they have a good reason, at least, or at least if they're clear about their reasoning. But the trust doctrine itself, was first sort of mentioned as part of federal Indian law in Cherokee Nation versus Georgia, which we mentioned earlier. And this, you have to remember, in the 1830s, what was the federal government assuming was going to happen to Native peoples? They were either going to assimilate.
Vanish.
Go ahead.
Either they would assimilate or they would vanish.
Vanish, disappear, die, right? So that was kind of the assumption. So this trust doctrine thing is, remember the term about they're like the pupils and we're like the teachers. Okay, the American society is supposed to be demonstrating civilization, that sort of thing. Well, the question is, how long does the degree take? How many credit hours are required before we're done? When is the trust doctrine? When do we get rid of it? Well, this is the questions that people during the termination era were asking. They were saying, well, look, this is kind of ridiculous. we got to start treating Native peoples like everybody else, not wards of the government, right? So in that sense, that's the termination era. That's kind of the philosophy of it. In many ways, the idea was, well, let's respect these people and quit treating them like you know the losers in a war or something. So the question is, do the benefits of the trust doctrine outweigh the limitations it produces? It definitely produces limitations, as we've seen. But if you took away the trust doctrine, would sovereign tribal nations even exist? Would they cease to exist? I don't know. Well, let's take a quick break, and we'll try to move on and look at the Mitchell cases, and then get into land and talk about Indian title. It won't take quite as long, I don't think. Well, if we're talking about a trust, the trustee in a trust has what is referred to as a fiduciary duty. Ever heard of that? Fiduciary. They have most of the time in trust law, a trustee is held to a sort of a higher standard than others. So, if someone is a trustee or a bank is a trustee for an estate, then they had better follow every accounting rule that they can, and be very transparent with the records of where things are and that sort of thing. It's often the case that a trustee is allowed to make investments and that sort of thing with the assets, and they can make mistakes, of course, but those mistakes have to be in good faith. So if the trustee fails, but the trustee is not really acted in the most prudent way to care for an asset, then they can be removed as the trustee. So it's really, and frequently if a bank takes on management of a trust as the trustee, what they'll do is they'll charge a pretty hefty fee to watch over those assets. Other times it's maybe an individual, a friend or a family member or something, but still the standard is a little higher for the trustee to make sure everything is recorded and is transparent. Now, what do you do when the trustee is incompetent? That's a good question, because the United States has demonstrated that its agencies can be quite incompetent, or at least disorganized. In the case of United States versus Mitchell, we have a couple of we're going to talk about Cobell in a little bit, but in the United States versus Mitchell, this is a case that initially this group, a group of from the Quinault tribe up in Washington. Washington State's in the news a lot, aren't they? Like Oklahoma. So anyway, this group in Washington State had a reservation. They went through allotment. Their allotments were covered with forests, and those forests, and by the way, the allotments were mostly still restricted. And as restricted allotments, they're still in federal trust. Well, can you think of all the agencies of the federal government that are responsible for managing forests? I initially think of the United States Forest Service, which is an arm of the United States Department of Agriculture. However, the Department of the Interior also is involved in managing forests through like the National Park Service. Okay, believe it or not, there is the Bureau of Indian Affairs is also involved with managing forests, managing land, like the Bureau of Land Management. Um, so, in this case, the Department of the Interior, through the Bureau of Indian Affairs, had harvested or contracted to have timber harvested on allotments that were still in federal trusts, and the holders of those allotments, those the native peoples who occupied those allotments or um, had those allotments in trust, did not receive any sort of compensation for the loss of that natural resource located on their allotment. So this became an issue, and the lawsuit was like a class action lawsuit against the Department of the Interior, and it went to the United States. It was a claims case after the Indian Claims Commission, so it went directly to the United States Court of Claims. The United States Court of Claims awarded this group damages from the federal government, and ordered the federal government to pay damages for for lost income from the timber that was harvested. Guess what? The Department of the Interior, Bureau of Indian Affairs, appealed. They fought the Indian tribe, okay, and they said no, we shouldn't have to pay damages, and it went. Of course, it's a United States Court of Claims, so it goes directly to the Supreme Court. Supreme Court reversed the Court of Claims decision and said the people who had this allotment, where the timber was harvested by the government, they did not receive any compensation, and they are not owed any compensation by the government. The government can come in and utilize the resource, and that's that. The Court of Claim, and so basically in 1980, and it's United States versus Mitchell because it's an appeal from the United States Department of the Interior. So the respondent in this case was the original plaintiff. So in the case of this group, they initially lost because the argument was that, at least according to the United States Supreme Court, that their argument, I guess, initially Mitchell's argument was, allotment produced this obligation for the government to manage our natural resources on our restricted allotted land. But the court came back and said that the principle of allotment, the whole idea of allotment was to encourage the allottees to manage their own resources. All right. So the idea, the spirit of allotment was to have native peoples responsible for their own natural resources on their own allotments. Now the allotment process, let's see, I'm not sure exactly when that reservation was allotted, but we can guess it was before 1934, can't we? So do you see any problems with this, with Mitchell 1? I mean, if you've read Mitchell 2, you would know what the problem was. So there's an allotment policy in the 1880s, 1890s, right? And it says, allottees live like whites, and then in the middle part of the 20th century, 1970s or so, the federal government comes in and says, well, we're harvesting this timber and you all weren't utilizing it. Any problems with that you see initially? Well, one thing that I thought of, and this it's not really brought up in the second case, but it seems like when John Collier and the Indian Reorganization Act um, declared all existing allotments retain restrictions in perpetuity. In other words, you all who have allotments, you can never sell them. They're just going to be trust forever. You're never going to be taxed on it, but neither can you, will you have any incentive to capitalize on it. So, in other words, the rules kind of changed, you know? And so I would think that, if the government's going to say you can never sell the land, well, then the government ought to be taking care of it. It's going to be trust land forever. I'm not taking care of the government's land, right? I mean, it's my allotment, but why should I have to hire foresters or heavy equipment to come in and I don't have the money for one. Okay, so that's kind of the argument I see. It's sort of like the federal government did this as its policy, and then it changed the rules, and it still continues to have these expectations, even though the rules kind of made it impossible for the earlier policy to ever be followed. And we know what happened to allotted land, right? It's kind of frequently is not utilized fully. So, the other side of the government's argument, the other side of the government's argument was that, I guess I wrote it up here on the slide, is that the initial reason for the restriction on the allotment was to prevent the state from taxing the land, and therefore the allottees would retain it. Okay, so they lost that case, but then, and I think it was Thurgood Marshall who actually read the opinion of the court. I think it was, and you know what he did was okay. So here's the Supreme Court saying, Quinault tribe, sorry about this, but government doesn't owe you any money, and the reason it doesn't owe you any money is because you really haven't shown us a good reason to realize why the federal government might possibly have a liability to compensate you. In other words, he kind of winked at, and basically said, and what they did was they kicked the case back to the lower courts without eliminating it. And 3 years later, the lawyers kind of took note of all this. Basically, what the court was saying is, give us a better reason to hold the government liable, right? And so they came back in 1983 with a new case, and in this time, you remember what happened? Basically, they just gave a sort of a history of the management of this forested land by the federal government. And it turned out that somewhere, a decade or two earlier, Congress had given the Department of the Interior some authority to harvest timber, and they had, actually not Congress, but the Department of the Interior had created administrative rules. All right, remember those? The Department of the Interior had an administrative rule to harvest timber on the trust land, and then use the proceeds of that to pay for Bureau of Indian Affairs work. All right. So basically, keep it in the BIA pot, and also to compensate the tribe for certain things. So what happens is the Interior Department, through its administrative rules, somehow kind of looped Congress into it all. Okay, so these statutes were passed by Congress without recognizing how it would affect Indian tribes. So, in other words, what happened was the first case gets kicked back. The Supreme Court says, surely you can find a better thing to hang, the federal government's liability on. And so they found these statutes where the idea of allotment sort of was made moot, to put it in a dumb way. So the idea here is that, okay, you have the trust doctrine, right? Lands in trust for the benefit of the Indian tribe or the individual. And even when something like the allotment policy, has this purpose, and over time it becomes, maybe irrelevant, Congress can, if Congress creates new laws, it can basically increase the degree of trust that it is responsible for. Not the greatest explanation. In other words, Congress can, just like it can break treaties, it can get itself deeper into its responsibilities as the trustee. Does that make sense? Okay, I hope. It's a difficult idea, but essentially, Congress is not off the hook. Congress is, Indian tribes are still around, so Congress can, if it passes certain laws, it better be careful, or else it's going to wind up causing some kind of what sort of a trust liability. Or actually, the term is, it comes in after the case of United States versus Sioux Nation, basically creates a oh no, it's after this case, what's called an enforceable trust obligation. So enforceable trust obligations can be created with new laws. Right? The government is not off the hook. Law can create enforceable trust obligations that did not exist previously. And there are a couple of other cases, but we won't talk about them at this point, that maybe help understand that. But let's talk about the United States versus Sioux Nation. Okay, so this is the United States versus Mitchell. I'll put those up. That's about all of my slides I have today. So I'm gonna quit screen sharing with y'all, if that's okay. Stop the share. Okay, here we go. All right. Violations of trust. And I'm going to turn this off. I don't have any. My slides are pretty rough now. So, I'm going to shut that down and we'll just talk. In the case of the Sioux Nation, this was about the Black Hills, right? And the story of the Black Hills. It was part of the Great Sioux Nation, 1868, part part of the Great Sioux Reservation, and the Black Hills were, the idea was that they would be part of that reservation forever, and the during the Indian Claims Commission days, or as I mentioned earlier, the Sioux, brought this forward, and it was obviously it qualified as a taking by the United States government. The point here in the trust chapter is that the taking of the Black Hills required some sort of just compensation under the Fifth Amendment. Okay. But what we find out here is that the question is, are tribes subject, or are they protected by the Fifth Amendment? And this is a long case. Congress developed a test for what's called a good faith effort. All right. Anyway, let's skip over that since I'm getting bogged down by it. The last short piece here is the Cobell litigation in this chapter, and what that is, it was a long. It went through so many departments, or so many secretaries of the Interior, that they just call it the Cobell litigation. Yeah, but it initially started off with a plaintiff by the name of Cobell, all right? And initially it was like Cobell versus Salazar, I think, or maybe that was the last one. What it was a class action lawsuit against the Bureau of Indian Affairs for mismanagement of what are referred to as individual Indian money accounts. Individual Indian monies are those assets that are derived mostly from allotted lands. And the Bureau of Indian Affairs was subpoenaed numerous times to, in this case, to show records and to provide or produce records of these assets that thousands of people had, tens of thousands of people had, and it couldn't do it. After years and years, it couldn't do it. The government continued to stall. So this is the example of the government. What happens when the trustee is incompetent? In the case of the Cobell litigation, the Bureau of Indian Affairs was unbelievably disorganized. They didn't have an answer. They were asked to provide the records, show me the money. Remember that? And they couldn't show anybody the money. So a correction of Congress initially attempted to correct this with a $3.4 billion award to the class action. However, the number was predicted, or at least assumed to be much higher in the $40 to $50 billion range. All right, so enough of that. Trust.